Tim Blankenship here with Divorce661.com. Sorry for the slow start. The recorder's a little quirky today. Anyways, this is the daily perspective of Divorce 661 for January 7th, 2025. We're going over a day in the life of an LDA. It stands for legal document preparer or legal document assistant, LDA, also known as paralegals. Today was pretty crazy. We are probably busier this year, first 7 days of 2025 than any year in the past. Don't know what's going on exactly. Probably a lot. We get a lot of referrals, so I know that helps. A ton of marketing, ton of videos, and just being in business for this long. We have over 100 Google 5-star Google reviews, so I'm sure all of that helps, and I appreciate all of your business. But this is January 7th. With all of the business that we get in on a daily basis, we still are able to take on new cases through technology, through being and specializing in just divorce and not having to jump from different areas of law and trying to figure things out. We have become so proficient in the divorce process, amicable divorce process, that is, that we just really know what we're doing is all I can say. We file in every county. We file a ton of cases. I want to say we did over 600 cases last year for 2024, which I don't know if there's, I know attorneys aren't doing that. I don't think there's, if I had to guess, I don't think there's anyone else that prepares more amicable divorce cases anywhere in California. If you're watching this and you are one of those companies, let's talk. I'd like to know what you're doing, honestly. Okay. First thing we're going to do is we're going to go off today's stats. Three new divorce cases today. We had one, and I'm going to go over and talk about some of the things and see if you guys can, if some of this helps you guys out as far as what's going on here. So first one, LA County divorce case. The petitioner, the wife, contacted us to start the divorce process. Her spouse is living out of the country. I recommended that we make the out-of-country spouse the petitioner, and here's why. And we do this a lot. We have folks, I forget where they were at. It was not, it's like Indonesia or something like that. It was someplace we haven't had clients before, but we've had clients in Mexico, Canada, the Philippines, you name it, deployed overseas. And if you're amicable from a procedural standpoint, the best thing to do is make the out of country, out of state, even out of country deployed spouse the petitioner. And here's why. If you're the petitioner, when we go to draft the settlement agreement, most courts don't require you to have a notary for the petitioner because you've made an appearance by filing the petition. So you've made an appearance, and the court, for some reason, feels like they don't need you to notarize, because I don't know of a single court that verifies your identity when you file a petition, but whatever, that's their rule. Same goes for the respondent. If the response is filed, they usually don't require a notary. Our process is that we follow is default with agreement. So we need both. We will have both spouses notarized in most cases, because there's some other reasons you need to notarize: long-term marriage, termination of spouse support. Some judges just want it. So just by default, we'll have both spouses notarized, except in cases where we know it's going to be difficult to get the notary. So if your spouse is out of country, we make a petitioner, we're just not going to set them up for notary. Only respondent will get their signature notarized, and that will solve the problem. So that's what we did here. Even though the wife was living in LA and her spouse was in out of country, I said, hey, you guys are amicable? Yes. Okay. Let's make them the petitioner. They were on board with that. Chatted with both of them via email. And so that's the plan. That's what we're going to do. And we're not going to have any issues, because I do have the client who hired us after they filed for divorce. And in a similar circumstance, they thought, well, I'm the one living here in California, so I should be the petitioner. They file, and then they started running into trouble with serving their spouse. And that's another problem. There's all kinds of different laws that go into place as far as serving if they're in a different country. And if you're not amicable, forget about it. It's going to take you a long time to get that through. We don't take those. But if you are amicable, even if you filed, we can still handle the service. We just have them sign an acknowledgement form. We use our office address for them, so there's no international mailing issues. Then the only problem becomes the notary, because with the California courts, they're going to want that notary coming from the U.S. consulate in the country they're in. All right, moving on. Another LA County new divorce case. This one was a judgment prep. So we get two types of people calling us. People that are starting from scratch and we start from a brand new case, and people that thought they could try and do their own divorce, and then they get stuck and they call us to take over. That's what one of this was. When I say judgment prep, that means we're taking over a case and we're going to finalize it. No matter where you're at, if you just filed a petition or you've filed and served, or you've filed, served, did your disclosures, or you even did your judgment, your settlement agreement, turned it and got rejected, we can take over at any point. What happened in this particular case is they got all the way to the judgment phase and their judgment had been rejected multiple times. And we've seen over the years of doing this, 4, 5, 6, 7 rejections. And depending on the court, it can take 3 to 6, to 2 months, 3 to 6 weeks to 2 months before you get that back. It can be very frustrating and adds a lot of time. What we do in these cases when they've gone all the way to the judgment phase and turn them in, we don't just review their reject sheet. We don't just review the the judgment package. We have to have every document that was filed from the very beginning, even if it's several years ago. And we've handled cases 20 years, 30 years old, where we had to get, we request copies. And what it ended up being is a photocopy of the microfiche. Do you remember what microfiche is? If you're my age, you barely may know. But that's how they did that. And before microfiche, it was written in a book, and that we would get a photocopy of the page of the book of the entry. That's how old cases we've handled. So it can be very tedious, but we can take care of it as long as you guys are amicable. So that, again, that's what we do. We're going to review everything from petition to what they turned in, amend anything, correct everything, redo their settlement agreement, redo their judgment, get it out to them for signatures, and we can take care of that, not a problem. What usually comes up when we do these judgment reviews or we take over a case that's ongoing, whether it's been the judgment's been submitted or not, or it's been rejected or not, is we will find errors in the initially filed paperwork. And what I'm referring to is like the petition and the summons, mistakes like the petitioner's or respondent's name not being exactly the same on the petition as it is a response. That's an automatic stop of your case, even if they filed it, and they will file it. You can put John Smith on the petition. You can put John T. Smith on the summons, file it. The clerk's not going to say it's wrong. They probably won't even notice it. Even if they did, they're not supposed to tell you. They'll take your filing fee and stamp your form, send you off your way. You'll serve those. You'll get all the way through the process, turn in your judgment package. Even if your judgment package is perfect, they will reject your judgment and say improper petition and summons. The names don't match. And guess what you have to do? Let's say you took 6 months to finalize all that paperwork. Now you have to go back, amend your summons and petition. And guess what? You have to reserve it, restart the clock on the 30 days if you are doing a default with agreement, which I recommend, and then you can turn it back in. So it just adds an additional delay. It doesn't restart the clock on the 6 months as long as you serve the original filed papers, but it does reset the 30 days, because if there's you're doing a default with agreement, you need to let the 30 days go by again because they were served new divorce papers. All right. Next new client. Were these new clients? Yeah, these are the new cases. So the next new case we took was short-term marriage case. It was also a consultation from earlier today. They hired us right out the gate. They were referred to us. We love referrals. Thank you if you're one of our past clients. I don't know why you'd be watching this, but thanks for your referrals. And they've been separated for about a year, and they were super amicable, which is good. All of our clients need to be amicable for us to get you through the process. And no children. There were just some assets and debts, a home, pensions, deferred comp, stuff like that. Their agreement was that each was going to keep their own assets and debts. If you watch my videos, you know it's very common that people do. It's really your call. It's not up to us, not up to the court. The court will approve whatever you guys want. We will lay it out in a way that'll make it approved by the court. So don't worry about that. Clients always say, hey, Tim, will they approve this? Or in our consultations, hey, I'm going to give my spouse 100% of the house. Is the court going to allow that? And the answer is yes. They're not going to call you and say, what, are you crazy? They don't care about you. They're going to make sure I's are dotted, T's are crossed, and procedurally the paperwork was filed correctly. So that brings us to 13 new cases for the year. When I say new to us, so new cases filed, taking over cases where people have started their divorce, and we are going to wrap it up for them. When we do wrap up those cases, just going back to that, like the case we took today in LA County, they didn't have their copies. It was filed about a year and a half ago. They lost them or misplaced them or what have you. With LA County, we can order copies pretty quickly. They charge us, and we ordered everything we needed to review, and we get them almost instantaneously emailed to us, which is great. Uh, Most of the other counties, it's not like that. In fact, most of the counties, we have to request a copy by mail, and we're talking a month before we get anything back, before we can even start to review and finalize your case, because we can't just hope and pray everything is correct and then move on. We're just going to get a judgment reject if we haven't reviewed the initial paperwork, because usually there's some errors there we need to fix, or if it's not on the summons petition, maybe on some of the procedural documentation, procedural forms that were filed prior to the judgment that would cause issues. Because, like I said, anything you filed up until the time you submit your judgment is not reviewed by the court. They're not looking at it. They're stamping it, send you a copy, and putting a copy in your file. Not until you turn in the judgment are they going to pull your file and do what we do and go top to bottom to as far as review, to make sure there's nothing that would cause your judgment to reject before they even review your judgment. All right, so let's talk about some of the consultations we had today. One of them was the first one was a gentleman who wanted to modify his spousal support, which we can do if you guys are in agreement. If you're looking to modify any terms of your prior judgment, so this is already, they had attorneys, I think 9 years ago they got divorced, and he's paying spousal support, and he wanted to modify it. He said, "How can we go about do that?" And I always ask, do you guys agree?" "Oh no, she'll never agree to modify this." He had his settlement agreement. I had him read it to me, just that portion about what the judgment or terms of their agreement was related to spouse support. And essentially it said it was X amount for an indefinite period of time. And because it was a long-term marriage, that's pretty typical of what you're going to see if someone's trying to get everything they're entitled to. So I told him, look, that's not something we handle. If you guys are amicable, it's easy. We draft a stipulation to modify the terms of the agreement. We could say, hey, it was X amount. Now we agree to this lower amount. They sign it, sign it. We don't need a notary. Becomes a court order once the judge signs it, and you're good to go. If not, you have to file a request for order. You have to go to a hearing. You have to explain away why you think it be changed. And that is interpreting the law. You have to look at what are some of the reasons you can ask for it. It's been a long time. I paid it for 9 years. She should become self-supporting to this point, et cetera, et cetera. We don't get into that. We don't give legal advice. So I referred him off to an attorney. In fact, he had an attorney before he was happy with. And I said, if you're happy with him, why don't you go back to him? And he said, well, I don't want to pay the cost of an attorney. So, but I think I said, at least have a consultation and say, hey, is this a crapshoot, or do I have a pretty good chance of getting that modified? So that was one. Second consultation. Let's see what we have. This was a current client. Just a kind of a unique situation here. And we just did this earlier. I don't know if I talked about yesterday, but we just did this literally yesterday on Monday. But if you want to predict, or you want a specific divorce date for some reason, then it's all based off the date of service, not the date of filing. Okay. So hang in here with me, because there might be a reason you want to do this. And usually we get this around June-ish, where people are like, hey, I don't want my divorce to finalize until January 1st of the following year. Or maybe they say, I want it to finish on the end of this year. And I would say there's two rationales. The people that want their divorce to finalize at the end of the year. So we're January 7th. And in this case, they said, hey, Tim, we don't want our divorce to finalize until December 31st, 2025. So the last day of the year. And that was for health insurance purposes. And so that makes sense. So we filed the case last month. And so they already got us their settlement agreement terms. So we could literally finalize their case and have it approved in a couple of weeks. With LA County, but they said, hey, we don't want this approved until December 31st. I said, that's not a problem. We will date the date of service, not until June of this year, June, I think it was 30th of 2025, as them being quote unquote served. They're going to sign a notice and acknowledgement dated June 30th. And if you count out, if my math is correct, 6 months in a day from June 30th, that should put us at December 31st, 2025. Now, we don't have to wait till December to file this, because it is LA County with e-file. And what's nice is once December, so when they date it June 30th, trying to keep track here, when they date it June 30th, 2025, 31 days after that, we can e-file it. So we call it July 31st. We can e-file it. And then it's about a week for approval, and they'll be done mid-July, let's call it. Well, Tim, you said you don't want the divorce done until December 31st, correct? So it'll get approved, but because we dated, so it'll get approved in July, let's say, but the final divorce date, the dissolution date that will be stamped on that form will be December 31st. Because they'll say, yeah, it's approved, but because of the June 30th service date and the notice of acknowledgement, due to the 6 months, pushes that and forces that date out 6 months in a day to December 31st. So that's one thing you can do for, like, if you want to extend it to a certain period of time, but you want to get the divorce done at the same time. The other way would say we want to push this until the following year, because they wanted to do it for tax purposes. So if you're divorced even one day in the calendar year, like let's say with this case for December 31st, well, that is the last day. So let's say the dissolution date is December 31st of 2024. Well, they were single one day in 2024. So for tax purposes, they would file. I'm not a CPA, so I'm not going to give you any tax advice. I'm sure they have the option of filing married joint or married filing separate, or they file separate. But I would imagine it'd be filing separate because they were divorced at least one day in the calendar year. But let's say you want to do that for 2025. We would do the same thing. We'd probably just do a July 1st date of service, and that would force it into 2026, and then you'd be married the entire year of 2025. So just food for thought if you're trying to get a specific date for some reason. It happens every year. We have a couple of folks that want to do that. Okay, next subject was short-term marriage, less than 10 years and separated for over a year. Extremely amicable. One spouse has been covering the expenses of the other. And the reason I wanted to bring this up is we were talking about the difference of how do we classify monies being paid to one spouse or another if you guys are super amicable. Should it be spouse support? Should it be based on the specific needs and costs? And what these folks were doing was the spouse was finishing up in school. Again, keep in mind, guys, if you're watching this, like, who would ever do that? It's super amicable clients that we deal with to one degree or another. And so they've been separated for a year. He'd been covering costs of housing and other costs, expenses, and so forth. And that's the agreement they had. They decided to file in the new year. So it was the first week of January. And so we did that. And he's going to be covering costs that go beyond when our divorce is going to be over right in 6 months and a day. It'll be approved. We'll probably be done with them in 2 weeks, meaning everything done, case filed. They hired us today. They signed today. We e-filed today. We'll get a case number tomorrow or Wednesday. Yeah, Wednesday or Thursday. And then they can provide us their settlement agreement terms, and we can get that knocked out in a couple days. Or even same day in some cases. They can sign it, notarize it, then we wait, and then we can submit it for approval 31 days after the date of service. But they have agreements that he's going to pay into the future. I told him, I think because you're paying for housing and for expenses, I don't know what it was, but I would assume like gas and maybe a car payment or, whatever that might be, whatever the expenses are, it doesn't matter. We shouldn't classify that necessarily as spousal support, but you're saying, hey, I'm going to pay this cost and this amount for these two items up until whatever date it was. It was sometime towards the end of 2025. That way, what we're doing is it makes for a cleaner settlement agreement, because there's not a open-ended spouse support that says, hey, we're paying spouse support from January to October. It's just we're going to say in this case, there's no spouse support now or ever. We're terminating the court's jurisdiction over the issue of spouse support. So that's a dead issue. But there's a side agreement, not a side agreement. There's an agreement in the settlement agreement that's not classified as spouse support that will say the petitioner is going to pay the respondent X amount of dollars for the following months for the following items. And that's how that will be addressed. And that's totally fine. It's still a court order. It doesn't matter that it's not addressed as spouse support, because spouse support for many years, probably if I had to guess 8, 9 years, has not been tax deductible, meaning the party paying cannot write it off and the party receiving cannot claim it unless it was built in, prior to this change in policy. In regards to that, those were grandfathered in many cases. But if they're new once post this change in policy or law, it's no longer deductible. So just keep that in mind. So there's no issue with us changing it from non-spousal or from spousal to a non-spousal type agreement. Um, Last consultation of the day was a client asking, not client, potential client consultation asked, hey, we want to know what's the fastest way to get your divorce finalized by the court. And I've talked about this in the past, and I've done this in the past purposely. I've had people watch the video they did in the past say, hey, Tim, I watched this video, and that's what we want to do, just because we just want to get it over and be completely done. So let me walk you through this. When you file for divorce, you get a case number issued, right? The next thing you do, you're supposed to serve it. Well, maybe that takes a week, 2 weeks, a month for whatever reason, because you don't know that you could just have them sign an acknowledgement form. Like we purposely have our clients, the respondents, sign an acknowledgement form the day after filing. So there's really no delay there. But because we treat this as a default with agreement, because that default has that 30-day wait before you can turn in your settlement agreement for review and approval, there's that 30-day window that it's just kind of lost. We're just kind of in limbo. We usually use that 30-day window to work with our clients to get the agreements and their terms and go back and forth. And, once they approve it, get them to sign it, notarize it. Then we're waiting to turn it in to court after that 31-day mark. But if you want to do it even faster, and we've done this before, this is what you do. File a petition day one, Tuesday. Get a case number issued. I'm going to go with best circumstances here, and it's LA County because we get same day filings usually. File it today, get a case number issued in, say, an hour. Once we get the case number, add that to the response, file the response. Boom. Response is in. Now there's no 30-day wait because now it's an uncontested divorce case because the response has been filed and there's been an appearance by the respondent. Whereas default with agreement, that's why there's that 30-day wait. So we've done this where you file the petition, got the case number right behind it, filed the response, got the response is filed. The benefit of that is no one has to be served, but guess no one's being served in our process anyways because we're doing it by notice and acknowledgement. And literally that same day, we could submit the judgment, the settlement agreement, the entire package for review and approval. And we did this one time because it was LA County. We started early in the morning, 8:00 filing case number, 9:30-ish, whatever. We got the response filed and we'd already worked on their settlement agreement. We sent it out for electronic notary service. They signed it, notarized it. We upload all documentation and it was all received by the court and approved by the court in one day. So kind of cool. I mean, not trying to hype up, get your divorce done fast, but it can be done. Some people just want to be done with the process and not talk about it again, not deal with us again, not deal with their spouse again. Even though we did that, the 6 months and a day still applies. So from this file date and then the response date, even though we got the approval that same day, it would be 6 months and a day from the day all that happened. So just keep that in mind. It doesn't speed up the final divorce date. It just reminds me of a consultation I had last week I want to bring up in regards to being separated. They said, hey, Tim, we've been separated, 5 years. I forget the amount of time. So they said, well, I'm just glad I don't have to wait the 6 months since we've already been separated. It doesn't work that way. We've had clients separated for 20 years. You still have to wait the 6 months. The date, the 6 months and a day cooling off period starts at the date of service of the petition, the date of service, not the date of filing. We've had people file for divorce a year ago and never serve it and then call us to take over. And they say, hey, our 6 months up, we filed in whenever, 6 months ago. And I'll say, well, was it served? No. Well, unfortunately, it's not the file date. It's the date you served it. And that's why with our new clients that start from scratch with us that haven't started their divorce, we file it as soon as they hire us. And as soon as we have a file date and case number, we have the respondent sign the notice of acknowledgement the very next day. So the clock is started immediately. Now they can still take 4 or 5 months to get they can still take 4 or 5 months to get their agreement and their terms to us. That's totally fine. But at least we're not losing time on the 6 month process. And this happens a lot with people who use mediators. They'll go and see a mediator, doesn't have to be an attorney, just a mediator in general. And they'll spend 2-3 months in mediation and great. They got ironed down an agreement. They'll end up with either a memorandum of understanding that they can take to someone like myself who can turn that into a settlement agreement. Or if it was an attorney mediator, maybe they walked away with a full settlement agreement ready to be submitted to court, but they never filed for divorce. So they spend however many months in mediation, only to have lost, let's say they spent 3 months in mediation. I'm not saying day in and day out. I'm talking about they go on Fridays for mediation, or one day a week or something. But and it takes time, because then the mediator has to draft the agreement. You guys come back, you meet, there's some back and forth on that. So imagine you spend 3 months in mediation, you walk out, you're done, you're happy, and this is what happens. They call me, hey Tim, we're done with mediation, but we just found out our divorce wasn't finalized, or hasn't been started. And I said, yeah. So that 3 months that clock could have been ticking this whole time, and he'd be that much closer to the final divorce date. So when clients call me that aren't 100% amicable, and I'm feeling like, I don't know that we're a good fit just now, maybe you need some mediation and you can come back to us, I'll tell them, that said, I can your petition and have your spouse sign the acknowledgement, start the clock on the 6 months. You guys go take all the time you need, do mediation or whatnot, sit down at the kitchen table, however you get that done, hash those details out. And wherever that happens, come back to us and we can pick up, move on. And because we started the clock, that's not lost time with your divorce finalizing. All right. So we're going to talk about some client success stories. And just specifically handling a high volume of cases. Told you we've already had 13 cases in the first week. Keep in mind, I'm talking about the first 7 days. There was a holiday and a weekend in there. So it's probably like 4-ish business days where this has come in. And despite the amount of new clients that we have coming in, we're able to maintain our efficiency, honestly, I believe, to our advanced technology, artificial intelligence that we use, the systems in place, the fact that we specialize only in divorce, the fact that we know exactly what we're doing in your specific circumstances. And I recognize that everyone has a separate circumstance. So we're always having to say, okay, well, here's what's going on and here's what you're trying to do with your agreement. I think this is how we should package it up, et cetera. We're not jumping around from different areas of law and kind of being a generalist. We are a specialist in amicable divorce. Additionally, we have the AI. We have our AI Rosie answering machine, which we had a high volume of calls. Yesterday, we had 18 inbound calls that were handled by AI that's actually scheduled the consultations for us. That would have been a full-time employee. And that actually helps us keep our costs down. There's a receptionist that I don't have to employ to answer the phones. And to be fair with you, many of the folks that call us are unqualified, meaning they're not amicable, or they want some type of service that we don't offer. A lot of people do a lot of due diligence, which I'm glad. They go to our website, they say, oh, he's not an attorney. It's a paralegal service or legal document preparer that specializes in amicable divorce. Oh, I'm not amicable, or we're not in agreement, so I can't use them. They don't call. But some people find our Google, our 5-star Google listing and 100 5-star reviews, and they just hit the call button and they have no clue what's going on. Well, through AI, through Rosie, the Hey Rosie app, I hope I'm not confusing you, she will pre-qualify you. And if you want to schedule a consultation, she'll happily send you a link to schedule it. And then we have more pre-qualifying questions on the website. So you go to the website, divorce661.com, schedule the consultation, and it'll ask, we have some forms built in, like some smart forms that say, are you amicable? Yes. Okay. You can continue on to the next thing. If you say no, guess what? It says, sorry, we'd only handle amicable clients. And so that eliminates the amount. It's kind of a funnel, if you will. And I don't know why I'm telling you this as a client, maybe more from a business perspective. If I answered every call personally that came in, at least 50% are not qualified to work with us. I mean, we don't do contested cases. We don't do cases going to trial. We don't handle domestic violence. We don't handle, even if your spouse is uncooperative or not participating. Any of those, we are talking about streamline. You guys are in agreement. You're at whatever the terms are, from there's no assets, no debts, no kids, and you were married a day or a week, to 40 years married. I think the longest one we did 70 years married, ton of assets and debts and pensions, 401ks, rental properties. As long as you're amicable, we can assist you. The being amicable is the number one issue, but happy to help you guys out. We can take on a high volume of clients because we're specialized in this. Been doing this a long time. We have artificial intelligence and systems in place. We use a client portal for communication, so everyone's on the same page. We use electronic signatures. I was just talking today about we've changed. For years we've used client management portal. We just changed over to a new one, a competitor. that is all cloud based, which is nice. So we're not downloading to our computer or to our drive. All of your records go into the cloud, secure portal. Nothing's on my computer. Nothing's on my staff's computer. It's all in the cloud. It's all secure. It's not no one. We're not sending emails to you and all that and unsecured emails and you're emailing me and your spouse wasn't CC'd. No, all communication is in the portal. It's all in the cloud. It's all secure. It's always between all of us, my team and myself and you and your spouse. See all communication. But that's how we operate. We can take a high volume of cases. We specialize in what we're doing. Um, and that's really what I wanted to talk to you about today. I'm just going to check my notes here and see if there's anything else. I have some closing thoughts. That we specialize in divorce. We can work very quickly with you. We use advanced technology to ensure that we are not sacrificing efficiency or quality. Thank you for tuning in to the Divorce661 Daily Perspektiv, episode 66. Talk to you tomorrow. I'm going to keep talking here because I am not getting this to turn off on me.